I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 1.2. This is part one of 3 short video lectures covering this rule. And Model Rule 1.2 addresses the allocation of authority between the lawyer and the client and the scope of the representation. So for my students, in this video, I'm going to cover the actual text of the rule or the provisions. There's A through D. And in the next 2 videos, I'm going to talk about the comments to the rule, which do matter and are important to be familiar with for purposes of the MPRE questions. So let's take a look at the rule itself. First, 1.2a. says that subject to paragraphs C and D, which are some kind of caveats or exceptions, a lawyer shall abide by a client's decisions concerning the objectives of the representation and shall consult with the client about the means by which they are to be pursued. So if you need to understand, if you're going to understand 1.2, you have to keep in mind this distinction between the objectives or overall purpose of the representation. Is your client hoping to obtain a monetary award? Are they really just trying to avoid jail? Are they trying to threaten litigation, but they really don't want to litigate? And things like that. So the client has to be in the driver's seat for that. Here, an example would be your client wants to sell their family business. It's been in the family for a few generations. A lawyer should not substitute their judgment and say, oh no, I'm going to thwart or undermine your ability to do that because I think you should hold on to that business or that property that's been in your family for generations. If the client is hiring you and their objective, what they want to achieve from their representation is to sell some real estate or a business or something like that, you have to abide by that. Now, then there's the question of how do we get there? And for that, usually the lawyer is going to be making the decisions, but you, of course, under the duty of communication, have to consult with the client about what the best way to do it is, what the fastest way, what the least expensive way, right? Should we litigate? Should we go to arbitration? Should we do mediation? And so forth. Now, let's continue. We're still in A. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. And so if a client has told you, look, I want you to file a lawsuit against this other party, somebody hit my car, here's their name and address, and I want to sue them for the damage, or this person damaged my my house or my business. And then you don't have to double check with the client about filing every document or pleadings and things like that. They hired you to do something. Presumably you had a big discussion during the consultation about what's involved. And now you can proceed with that. So that's going to involve trips to the courthouse, phone calls to the judge's clerks, or the court clerks or the opposing party and so forth. And if you are still acting within kind of the implication of what the client told you to do, then you don't have to get express authorization for every little thing that you do. Keep in mind, and by the way, you are almost guaranteed to have a test question about this on the MPRE. You must abide by a client's decision about whether to settle a matter. And that's true in a civil case or a criminal case. So if your client wants to accept a plea bargain, even though you think you could get them an acquittal at trial, it's their decision. You are not allowed to substitute your decision for your client and turn down, let's say, a proffered plea bargain or plea deal without asking them. And this same is true in a civil case. So if the client doesn't want to accept a settlement, you can't, and you think they really should because the settlement is better than you're likely to do at trial. If they want to go to trial, you have to go to trial. And if they want to accept a settlement, even though you think you could do better at trial, you have to accept the settlement. It's an absolute rule. The lawyer shall abide by the client's decision whether to settle a matter. In a criminal case, as I said, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, and also other rights like whether to waive a jury trial and whether the client is going to take the stand and testify. Let's move on to 1.2b. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. In other words, let's say you get a hypothetical of some really awful person, right, who's committed heinous crimes and atrocities. If you are the lawyer who's appointed, you're not going to be subject to discipline for representing someone, a client, who just happens to be a really awful person, right? So they get a lawyer too. It's part of our way of making sure that the system is fair and that any punishments we dole out, whether civil or criminal, are the person had every chance to present their side of the case. And so the very fact that you're representing someone does not mean that you endorse all of their views. In fact, you're free to disagree with them. And so that for purposes of a test question, keep in mind the answer is the lawyer will never be subject to discipline merely for representing someone who is a terrible client or a terrible person. Now, in practice, if there are certain clients that you just wouldn't be comfortable representing, right? You don't want to represent certain types of criminals, or you have very strong feelings, let's say, about abortion or abortion rights. So that would prevent you, you feel like, from representing Planned Parenthood, or vice versa, from representing a pro-life protest group or something like that. You can decline the representation if you don't want to do it. But if you do decide to proceed with the representation, then from the standpoint of disciplining a lawyer, then we don't impute all of the client's behavior in political or economic or social or moral views or activities to you. Let's move on to C. A lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. So a client comes to you and they want to litigate, and you do litigation, but really only the pretrial work, right? And so that's a lot of the litigation is the pretrial motions and discovery and so forth, settlement negotiations and so on. So you could tell the client, I will do everything up to trial, but if the case ends up going to trial, and most cases don't, right? But if your case goes to trial, you're going to have to get another lawyer to do your trial because I don't like courtroom work. I like doing the pretrial motion practice and discovery. Conversely, let's say that you're a trial lawyer and you don't like doing appeals because doing appellate work involves so much library research and writing really much longer briefs and so forth. And so you can limit the scope of the representation to something like, I am only doing your trial. If you decide to appeal or the other side appeals, I'm out. You're going to have to get somebody else who's an appellate lawyer to do the appeal. The same is true with appellate lawyers. A lot of times, if one side wins on appeal, the losing side, then we get a remand for a new trial. Well, if you only like doing appellate work, you might want to limit the scope of the representation, make sure your client understands you're not doing the trial if the case gets remanded after the appeal. If you only like doing transactional work, you might want to limit the scope of the representation, just make it explicit with the client in writing that if there's litigation, you don't do litigation, you only do transactional work and so forth. All of those things, examples I just gave, are reasonable. It's conceivable that you could come up with an unreasonable limitation. So for example, the client wants you to litigate, but only wants you to spend 5 hours total on the representation. Well, that's not possible, right? That litigation is only going to pre-trial, trial, post-trial work is all going to take less than 5 hours. And so that's not a reasonable limitation on the scope. And of course, the client has to give informed consent. D, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, right? So you don't tell the client to bribe government officials or destroy documents or hide their assets in offshore accounts or things like that. You can discuss the legal consequences of any proposed course of conduct with a client, and you can counsel or assist a client to make a good faith effort to determine the validity, scope, or meaning or application of a law. And so I want to explain what we're talking about here for a second. Let's say that there's some unsettled questions of law if certain activity would fall under the statute prohibiting something or not. And so you can have a conversation with a client about it's not, let's say it's not clear if the statute would apply, if the law would apply if you did this, or if, let's say, you had a partner in another state, or you were engaged in this conduct through a corporation instead of an individual, or if you already had a permit, or if you provided notice up front. There's a number of things like that that are not don't necessarily count as coaching someone about how to commit a crime or get away with a crime. It's a good faith effort to figure out where's the boundary about what's legal and not legal, or what's the scope or application of the law. Do we think the law would still be valid, right? That's the validity. Or do we think that this law is going to be held unconstitutional if there's a test case? All of those are fair game to discuss with your client. And that concludes my first kind of quick overview of the provisions of Model Rule 1.2. Please watch the next video, which goes into some detail about the comments, where the ABA sort of fills in some gaps of the rules and clarifies some things. And a lot of the examples in the comments, I think you're likely to see show up as test questions. And so that will be video number 2 in this series.